Welcome back to the Deep Dive. This is where we take the densest, most high-stakes stack of source material we can find, we rip it all apart, and then distill the knowledge you need to be perfectly informed.
And today's stack is, well, it's pretty extraordinary.
It really is. We are looking directly into the legal DNA of the entire artificial intelligence age.
We certainly are. I mean, this isn't just some corporate lawsuit. It's the ideological and financial collision of the century. We're about to plunge into the specifics of the high-stakes legal showdown between Elon Musk and OpenAI.
Exactly. And our sources, which include some really detailed legal analysis, they tell us that this trial, which is scheduled to kick off on March 30th, 2026,
Yeah.
it's anticipated to be an event that just completely transcends the courtroom.
Yeah, I saw that. One source actually suggested the public anticipation will be much, much wider than even the O.J. Simpson trial.
Right, with, and this is a quote, the whole world
hmm
watching to see how the future of AGI is going to be governed.
And the meta-narrative here, which I think elevates this case beyond any tech litigation we've ever seen, is its connection to AI itself. I mean, the legal blueprint we're about to unpack. It wasn't synthesized by a team of human paralegals working late nights.
No, not at all.
Our sources relied specifically on a competing AI Gemini 3 to generate and refine the most probable, most potent, and strategically cohesive arguments that Musk's legal team is expected to deploy.
So just to spell that out for you.
Yeah.
We have an AI providing the legal strategy to take down the company that is right now leading the AI revolution.
Yeah.
The irony is just staggering.
It's unbelievable.
So our mission today is laser focused. We're going to analyze these 30 specific arguments that Gemini 3 generated. We're looking not just at what the claims are, but at the legal mechanisms the Musk team will probably use to try and prove them.
And if you just step back for a second and look at the whole strategy, it really boils down to three core kind of emotionally resonant themes that Musk's team will hammer home to the jury. They're framing this entire thing around the transition from what they call a humanitarian, save the world mission to an aggressively commercial enterprise. So the whole narrative is built on deception, greed, and broken trust.
Deception, greed, and broken trust.
Right. We're going to see those three pillars underpin everything, from the breach of their nonprofit status all the way to allegations of market manipulation.
That is the perfect frame. So let's just jump straight into that first pillar. This is the one that addresses the very foundation of the company, the integrity crisis. Okay, so let's unpack these foundational claims. The idea that the company fundamentally betrayed its charter the moment it switched tracks.
This first section is absolutely crucial because it attempts to show that the original contract, the one they made with the founders, with the public, and with the government through their nonprofit status, was systematically and illegally breached. It's an integrity crisis framed as a series of severe corporate and charitable law violations.
Okay, let's start with what the sources say is the single most crucial legal attack. Core argument 1. The abandoned mission. Musk's team is going to argue that OpenAI just flat out abandoned its original founding agreement, an agreement that was legally binding and said they had to develop AGI for the public benefit, not for private profit.
Right.
So what does public benefit actually mean in a legal context, and why is that switch such a devastating claim for them to make?
Well, in the U.S., a 501c designation, which is what OpenAI originally had, isn't just a tax break. It's a solemn legal dedication. It means the purpose of the organization, its entire mission, its assets, all of it must be irrevocably committed to the public good, whether that's education, charity, or in this case, scientific advancement for broad open use. The switch to a for-profit structure, even one they call capped profit, legally just inverts that entire premise.
It's a total reversal.
It's a total reversal. Musk's team will argue that the moment the board shifted the primary goal from developing AI that benefits all of humanity to maximizing return for commercial investors, they legally invalidated the very existence of the nonprofit entity, and in doing so, breached that foundational agreement.
The implication there is just massive. They're not just arguing a change in priorities, they're arguing a fundamental breach of their legal right to exist as they were.
Precisely.
And that foundational betrayal leads directly to the money, right? This is where we get core argument 2, the bait and switch on donors. How does the pivot to for-profit legally become a bait and switch, targeting those early charitable donors?
The term bait and switch is so potent here because it implies fraudulent inducement. Many of the early contributions, Musk's included, were treated as charitable donations, so they were tax deductible, given without any expectation of an equity return.
Right, those for the cause.
Exactly. The argument is that these funds were solicited under the representation that they were building a public good, a global open source safety net. So if the company then uses those non-recourse charitable funds to develop highly profitable proprietary commercial products,
Then it wasn't a donation to a charity.
right. Musk's team can claim the founders essentially misrepresented the true purpose of the funds from day one. It's a retroactive violation of the donor's intent.
I see. So the money was given to build a public park, and they turned around and built a private toll road with it instead.
That's a perfect analogy.
This brings us to a point that's more about culture and branding, but it's a really powerful narrative device. Core argument 3. Violating the namesake. The sources suggest that the shift from genuine open source research, sharing the code, sharing the data, to proprietary closed-door development violates the company's own name. The name OpenAI is now, they argue, a legal lie.
That's exactly the strategy. And for a jury, that's a narrative slam dunk.
Yeah.
I mean, if you look at the company's history, their early white papers were incredibly transparent. They really adhered to that open principle.
Not anymore.
Not at all. The closure of the source code for their most advanced models, like GPT-4, and the proprietary nature of their training data, it directly contradicts that original mission statement. Musk's lawyers will frame this as willful deception, using the name to attract talent and legitimacy, only to pull the curtain shut the moment the technology became commercially viable.
And the defense will say what? That they had to do it.
Oh, absolutely. The defense will argue necessity, that they had to close the source to compete or, protect against misuse. But that initial promise remains a very powerful piece of evidence against them.
This issue of purpose comes back to the core legal responsibility of the leadership. That's core argument 4. The shift in duty. This one claims the board's primary fiduciary duty has shifted dramatically. It's moved from protecting humanity, the original mandate of the nonprofit, to maximizing returns for its commercial investors.
This is the absolute legal core of the entire case.
So can you break down the difference between a nonprofit fiduciary duty and a for-profit one? Where was that legal tipping point?
Okay, so in a traditional for-profit company, fiduciary duty means you act in the best financial interest of the shareholders. You maximize their wealth. Simple. In a nonprofit, that duty is fundamentally different. It means you act in the best interest of the mission and the public good it serves.
Okay, that makes sense.
The legal inversion point, the tipping point, happened when they created that capped profit subsidiary that was controlled by the nonprofit parent. The moment that subsidiary began generating massive revenue and getting billions in commercial investment, the directors of that commercial arm suddenly had a legal duty to their investors.
And those duties are in direct conflict.
They're in total conflict. Musk's team will argue this new duty immediately overwhelmed the nonprofit board's mission-driven duty. It effectively forced them to swap their moral compass for a financial one. The pressure from investors demanding returns legally superseded the duty to humanity.
So, to use that hospital analogy again for you listening, if the hospital's duty shifts from patient care to profit, the staff's legal obligations immediately change. That sacrifice of altruism. It leads us straight to the most powerful partnership they formed. Queer argument 5, the Microsoft subsidiary claim.
Right.
What evidence will Musk's team use to prove that OpenAI has effectively become a closed-source subsidiary of Microsoft, even without a formal acquisition?
They need to prove de facto control. It's not about ownership on paper, it's about control in practice. The evidence will center on the exclusive licensing deals and specifically the massive computational resources Microsoft provided.
Server farms, the cloud.
Everything. The argument is that this made OpenAI completely reliant on Microsoft's infrastructure. Because Microsoft essentially owns the computing power and has exclusive rights to deploy the AI in its own software, OpenAI operates less as an independent entity and more as an R&D lab for Microsoft.
A very, very valuable R&D lab.
An R&D lab dedicated to furthering Microsoft's commercial market dominance. They'll look at shared roadmaps, key personnel movements, deep software integrations, anything to show that Microsoft is dictating the strategic direction, basically fulfilling the role of a parent company.
And if they can prove that, it just shatters the claim of neutrality. Let's move to core argument 6, the capped profit legal fiction. The claim here is that this whole capped profit structure, which supposedly limits investor returns to, 100x, is just a legal fiction, that it's designed to get around nonprofit rules while still making the insiders fabulously wealthy.
Right.
How can a capped return be deceptive?
Well, the deception isn't necessarily in the cap itself, but in who benefits and who doesn't. So while the outside investors might be capped at a defined multiple, the argument is that the real wealth for the founders and executives comes from other places.
Like what?
Associated equity stakes, complex vesting schedules in the for-profit subsidiary, a future IPO that could spin off parts of the entity. The lawyers will argue that the cap exists solely as a legal maneuver. It's there to maintain control under the nonprofit umbrella and attract early capital, all while preserving the bulk of the upside, the truly uncapped wealth for the managing partners.
That is just great.
It's an intentional smokescreen designed to look virtuous while facilitating private greed.
That's a sophisticated legal point. And that secrecy seems to be a theme. Let's look at core argument 7, secret milestones. This claims that technical milestones achieving a certain level of AGI that were supposed to trigger public releases of the tech were instead kept secret. Why? To maintain a commercial advantage.
Yeah, this is a big one.
But how do you prove a secret technical milestone in court? That sounds almost impossible.
You prove it through their own internal communications. Emails, Slack messages, meeting minutes, the original technical charter. The legal team will be digging for anything to show that the criteria for AGI or for that public release trigger were deliberately obfuscated or changed once they got close to the goal.
So if the original charter said, upon achieving level X, the code must be open sourced, and then
internal emails show researchers saying, hey, we've reached level X, but management instructs them to redefine level X or just conceal the finding. That's your evidence of willful secrecy for profit. Without that secrecy, their exclusive commercial advantage and therefore their valuation would immediately just evaporate.
Which brings us to the profound irony in core argument 8, becoming the anti-Google. The whole original mission was to be the counterweight to big tech monopolies, to be the anti-Google. But the argument is that OpenAI has since adopted the exact same monopolistic behaviors it was built to counter.
Yeah, the hypocrisy argument.
What specific behaviors are they targeting with that claim?
They're targeting the creation of what's called a data moat and an AI moat. By closing the source, by partnering exclusively for massive amounts of proprietary data, which we'll get to later, and by controlling access to the best models, OpenAI has created the same kind of centralized, walled garden ecosystem that defined early Google and Facebook.
So instead of democratizing AGI,
Musk's team will argue that instead of democratizing it, they've just created a new, non-transparent corporate power that will exercise the same market control. It's a complete abandonment of their anti-monopoly ethos.
the next point is directly linked to the consequences of that shift. Core argument 9, ignoring existential risks. By prioritizing commercial speed, the race to be first over methodical safety testing, OpenAI is allegedly ignoring the very existential risks its founders originally swore to mitigate.
This is the safety argument.
But what's the proof point that separates just being competitive from being dangerously negligent?
The proof is in their own internal safety audits and risk assessments. In a mission-driven entity focused on safety, you'd expect to see slow, deliberative rollouts, years of alignment research, extensive third-party audits.
All the stuff that slows you down.
All the stuff that, in a profit-driven race, is viewed as a revenue blocker. Musk's team will argue that the speed and frequency of their commercial releases, rushing major models to market to satisfy investors and beat rivals, shows a willful deprioritization of safety protocols.
So they'll look for specific examples.
They will look for instances where safety teams flagged issues that were overruled by commercial leadership who just wanted to accelerate deployment. The core claim is simple. Greed replaced caution.
And finally, rounding out this whole section on the foundation, we get to the money again. Core argument 10, weaponizing tax status. The claim is that the company weaponized its nonprofit status to gain an unfair tax-exempt advantage while building products that were always destined to be for-profit.
This is a powerful one for a jury.
How significant is that tax advantage for a company this big?
Oh, it's enormous. And it taps into that public idea of charity misuse. By operating as a nonprofit initially, they could solicit tax-deductible donations, avoid paying corporate income tax on early revenue, and use all that tax-exempt capital to acquire crucial, expensive assets.
Like GPUs and talent.
Exactly. High-end NVIDIA GPUs and top-tier talent that rivals had to pay full commercial price for. The argument is that they used a public tax subsidy to build their private commercial engine. If they had been an upfront for-profit entity from day one, their starting financial position would have been vastly different. It would have fundamentally altered the entire competitive landscape.
That's a stunning initial pillar. 10 arguments, all focused on the structural integrity of the company's founding purpose. So now we move from the institutional betrayal to the personal.
Exactly. This next section is strategically really important because, look, proving a breach of contract is one thing. But proving intentional fraud or deception, that requires demonstrating premeditation, malice even.
So they're going after the individuals.
Musk's team is targeting the individual conduct and intent of the leadership, trying to emphasize that this betrayal was calculated, not some accident.
What's fascinating here is that shift from corporate law to personal intent. I mean, to win on fraud, you need specific proof of someone misleading someone else.
You do.
Which brings us to core argument 11. Inducement via personal assurances. The claim is that executives, and they specifically name Sam Altman, use personal assurances in private emails to induce Musk into giving millions in seed funding, relying on the guarantee that the mission would stay nonprofit and open.
This is the legal money shot. Fraudulent inducement requires demonstrating that the plaintiff, in this case, Musk, relied on a specific false statement of fact. For example, a promise of permanence as a nonprofit. And that this statement was known to be false or misleading by the defendant when they made it. And finally, that this reliance caused financial harm.
So they need the receipts.
Yeah.
Email.
If Musk's lawyers can produce emails where Altman explicitly promised this will never be a commercial venture or the code will always be open source, specifically in the context of asking for funds, that is very, very difficult for the defense to counter. It puts the burden of proof squarely on demonstrating an intent to deceive.
And those private assurances allegedly came while they were already plotting the shift. That's core argument 12.
Yeah.
Concealed restructuring plans. The allegation is that executives deliberately concealed their long-term plans to restructure into a for-profit model while they were still actively soliciting nonprofit donations.
Right.
What kind of documents would prove that concealment?
They'll be looking for a timeline discrepancy. So if internal strategy meetings, board minutes, or financial planning docs from, say, 2017 or 2018 show detailed discussions about an inevitable commercial pivot.
While they're publicly saying the opposite.
Exactly. And during that same period, they were issuing public statements or private solicitations promising perpetual nonprofit status that demonstrates premeditation. Now, the defense will argue they were just exploring options, but Musk's team will argue the plan was cemented and hidden to ensure the funding kept flowing.
It's all about securing resources under false pretenses. And that includes talent, too. Core argument 13 is about leveraging the brand. The claim is that OpenAI leveraged Musk's personal brand and reputation to recruit top-tier, mission-driven talent, people who would never have joined a standard commercial startup.
The AI talent market is maybe the fiercest in the world. And the researchers who focus on existential safety and alignment, they often choose their workplace based on mission, not just salary.
Musk's name was a huge draw.
Musk's name, attached to the original nonprofit, gave OpenAI an almost instantaneous credibility, a gravitational pull for these elite researchers. The argument is that this talent, the very people who built the foundational technology, was acquired based on a fraudulent promise of altruism.
So they use his moral authority as a recruitment tool.
And the financial gains derived from that talent pool are therefore ill-gotten.
Now, for a technical argument that has huge financial ramifications,
Yeah.
core argument 14, misleading the public on GPT-4 AGI. The claim here is that management misled the public by saying GPT-4 was not artificial general intelligence, or AGI, solely to avoid the requirement to open source it as their charter demanded.
Right.
How crucial is the definition of AGI in this argument?
It's absolutely central, and it's a potential legal quagmire because AGI doesn't have a standardized legal definition. However, if the original founding documents provided even a working definition of AGI, maybe based on passing specific tests or showing certain capabilities,
they're on the hook.
then Musk's team will argue that GPT-4 met those internal criteria. By officially downplaying its capabilities as just an advanced large language model, management allegedly avoided triggering their contractual obligation to open source the technology, and keeping it proprietary allowed them to monetize it exclusively through their Microsoft partnership.
So the technical classification was actually a multi-billion-dollar financial decision.
That's the argument.
And that decision seems to be tied to the management's personal financial gain. This leads to the very serious allegation in core argument 15, self-dealing. This is the claim that management engaged in self-dealing by creating complex corporate webs that let them hold significant equity in related for-profit arms, all while using the nonprofit as a protective shield.
Yeah, this is a very serious charge.
Can you demystify self-dealing in a structure this complex?
So, self-dealing in a nonprofit context is when a person in a position of authority, a director or an executive, enters into a transaction that benefits them personally at the expense of the organization's charitable mission.
And the complex structure is what allowed it.
That's the allegation. Musk's team will argue that by allocating significant equity stakes in the for-profit subsidiary to the very same people who govern the nonprofit parent, those individuals inherently place their personal financial gain above their fiduciary duty to the public mission. The structure allegedly allowed executives to effectively commercialize a public asset while claiming the shield of charitable oversight.
This alleged lack of accountability extends to the people who funded the mission in the first place, leading to core argument 16. Failure to notify donors. They'll just hammer this point. The failure to provide early donors with the required transparency and formal notice before fundamentally changing the corporate purpose.
And this is a pretty basic standard of charitable law and ethical governance. When a nonprofit undergoes a fundamental, mission-altering change like creating a commercial subsidiary to monetize its assets, legal protocol usually dictates a formal notification period to major donors, sometimes even a consultation.
But they didn't do that.
The argument is that the executives acted swiftly and unilaterally, bypassing this transparency precisely because they knew that full disclosure would provoke resistance. It would provoke withdrawal of financial support and, crucially, legal action like the one we're seeing now.
If the financial incentives were really that dominant, we don't need to look any further than core argument 17, board powerlessness, the Altman incident. The removal and then rapid reinstatement of Sam Altman serves as, they say, irrefutable proof that the nonprofit board no longer holds any real power.
That whole event was a public trial of power, and the nonprofit side lost, conclusively. The argument is that the original board, the guardians of the mission, tried to assert their fiduciary duty by removing Altman, citing a lack of candor, which is a key requirement for nonprofit governance.
But it didn't stick.
Not for a second. The immediate devastating market reaction, coupled with intense pressure from commercial investors and Microsoft, forced his reinstatement. That whole incident, which played out over a single weekend, provides potent evidence for the jury. It showed that the financial stakeholders hold the true, ultimate governance control.
It rendered the mission-driven nonprofit board
merely a symbolic, impotent figurehead.
And the ultimate broken promise. Core argument 18. Exclusive licensing versus humanity. This starkly contrasts the original promise that the technology will belong to humanity with its replacement by massive exclusive licensing deals that benefit a select few.
I mean, this is the core philosophical betrayal.
What's the legal difference between a public good and a proprietary license in this field?
A public good, in the context of AGI, implies that the core research, the model weights, the code, it's all accessible to everyone. Researchers, small businesses, competitors, individuals, for free or minimal cost. It enables widespread scrutiny and use. An exclusive license means only one entity, in this case primarily Microsoft, gets preferential, often proprietary, access to integrate and monetize the tech.
So it's the opposite of open.
It's the complete opposite. Musk's team will argue that the transition from a shared global resource to a tightly controlled exclusive revenue stream for one partner fundamentally violates the spirit and the letter of that founding agreement.
We have to touch on the most serious financial claim in this section. Core argument 19, financial misallocation. This is the claim that financial records will show that donations intended explicitly for non-commercial, safe AI research were diverted to build proprietary commercial product infrastructure.
This is an allegation of criminal misuse of charitable funds. It's a major legal escalation. Proving it requires meticulous tracking of ledger entries. If a foundation donated millions earmarked specifically for human alignment research or existential safety protocol development,
and that money was used to buy GPUs for a commercial product.
And those funds are traceable to purchase orders for massive GPU clusters dedicated solely to training the proprietary closed-source GPT models, that's clear misallocation. Musk's team will seek evidence of these specific earmarking violations, arguing the leadership knowingly diverted public funds for private commercial gain.
Finally, to summarize this whole section on intent, core argument 20, orchestrated betrayal. The claim is that the defendants orchestrated a betrayal by waiting until the technology was intrinsically valuable after the nonprofit labor and charitable funds were secured before attempting to cash in. This implies a long-game strategy.
It implies cynicism and calculation. Now, the defense will argue the shift was forced by necessity, that the compute costs of reaching AGI scaled beyond what charitable funding could support.
What the prosecution will say.
They'll argue it was a timing strategy, that they waited until the technology was just powerful enough, just valuable enough, and the charitable mission had served its purpose of subsidizing all the hard, expensive R&D. And once the technology was ready to be a multi-billion-dollar product, that's when they intentionally flipped the switch to maximize their private return.
That transition from altruism to alleged calculated deception is staggering. So now we turn our focus outward, moving beyond the boardroom to how these actions allegedly damage the entire AI ecosystem.
Right.
Here's where it gets really interesting. This third pillar frames the lawsuit not just as a fight over one company's mission, but as a fight over the future governance of the whole AI industry.
This is Musk positioning himself as a defender of competition and open innovation. He's arguing that the actions of OpenAI and Microsoft are creating an AGI monopoly that suffocates rivals and harms the public. These arguments are designed to appeal to a jury's sense of fairness about the market.
We start with core argument 21, opaque monopoly. This is the claim that OpenAI and Microsoft formed an opaque partnership that effectively creates a monopoly over the future of AGI. Why is the word opaque so important here?
Because opacity shields them from conventional antitrust scrutiny. A merger is transparent, you can analyze it. But a partnership this deep, fueled by tens of billions in compute resources and exclusive licensing rights, it creates the same anti-competitive outcome without the formal legal process of a merger.
So no one can see what's really going on.
Musk's team will argue that because the full financial, technical, and data sharing agreements are secret, it's impossible for regulators or competitors to assess the true extent of their resource consolidation. This secrecy, combined with their dominance, lets them control the price, availability, and direction of the most powerful foundational models, and that is the definition of a monopoly.
And if they have an opaque monopoly, the natural next step is to stifle rivals. This leads to core argument 22, stifling innovation. This discusses the alleged use of no-invest edicts to prevent VCs from funding rivals.
This is a tricky one to prove.
How would they even prove such informal pressure was applied?
They would need testimony or correspondence from venture capitalists. In the tight-knit world of AI funding, if Microsoft or OpenAI leadership, incredibly powerful figures, informally signaled to key VC funds that investing in competitors was a risk, that it might jeopardize future access or partnerships, that can act as a powerful constraint on capital.
It's not a formal non-compete, it's a chilling effect.
Exactly. The argument is that they leverage their outsized market power to starve the competition of the essential computational and financial resources needed to catch up.
That dominance relies on those early, subsidized foundations, which brings us to core argument 23, leveraging donated resources. This emphasizes that the company's current multi-billion-dollar dominance was built on the back of donated hardware, subsidized labor, and charitable funds that were never meant to fuel a private, closed entity.
This is the competitive unfairness argument in a nutshell. Any rival startup trying to enter the AGI race today has to pay full market price for their compute time, their salaries, their data licenses.
But OpenAI didn't.
OpenAI got a massive head start because the first critical years of expensive R&D were subsidized by charitable donations and tax breaks. The prosecution will argue that this leveraging of public good resources created an insurmountable competitive advantage, a form of state-sanctioned subsidy that lets them dominate the commercial market now.
They built the foundation of a multi-billion-dollar entity using philanthropic funds.
That's the claim.
Next, back to the control mechanism with Microsoft. Core argument 24. Undue influence. Explain the mechanism of interlocking directorates that the partnership with Microsoft allegedly allows, giving Microsoft undue influence over the whole AI market.
So the term interlocking directorates usually refers to the same people sitting on the boards of competing companies, which is generally illegal. Here, the argument is about functional interlocking directorates. Even if Microsoft people aren't official board members, their critical roles as observers, technical liaisons, and primary capital providers mean they have unparalleled insight into OpenAI strategy.
More influence than a normal partner would have.
Far more. This level of influence means Microsoft can steer AGI development to align perfectly with its own enterprise software goals, effectively influencing the standards and market direction for the entire AI ecosystem.
Core argument 25 is maybe the most philosophical point in the whole playbook. Gatekeeping, a public utility. This is the assertion that by keeping its most powerful models secret and proprietary, OpenAI is gatekeeping what should be treated as a public utility, all for its own financial gain.
Right.
What's the justification for calling AGI a public utility?
The justification lies in its foundational nature. Musk's team will argue that AGI isn't just another software product, it's a universal intelligence infrastructure. It's like the early internet protocols or the electricity grid or the math behind encryption.
It's something everyone should have access to.
Exactly. If one secretive corporation controls the most advanced version of this foundational technology, they control access, safety, and application for every other industry on the planet. By treating it as a proprietary revenue stream, they are preventing the public scrutiny and equitable access necessary for safe, democratic, technological adoption.
And if their power is based on fraud and gatekeeping, then the financial result must also be suspect. Core argument 26. Ill-gotten valuation. The argument that the company's staggering valuation, tens of billions of dollars, is built on ill-gotten gains derived directly from a breach of charitable trust.
This argument aims right at the heart of the corporate value. If a company's success is based on a series of fraudulent acts soliciting tax-deductible donations under false pretenses, using those funds to build commercial assets, closing source code in violation of a charter, then the resulting valuation of that company is fundamentally poisoned.
So they're asking the court to, what? Unwind the company.
They're implicitly asking the court not just for damages, but potentially for an order that would unwind or legally nullify the commercial value created through the alleged breach of trust, essentially arguing that the entire enterprise belongs back in the public nonprofit domain.
Focusing back on the competition. Core argument 27, exclusive data deals. Detailing how exclusive data sharing agreements with Microsoft prevent a level playing field for other AI developers.
And as you know, data is the new oil. Training an AGI model requires immense amounts of data, clean, diverse, and proprietary data. Microsoft, as a tech giant, has vast repositories of this.
Enterprise documents, code, search data.
Everything. By funneling this proprietary data exclusively to OpenAI, they are creating a resource moat that is physically impossible for rivals to overcome, no matter how much compute power they get. The argument is that this exclusive data access is a deliberate, anti-competitive tactic that locks in OpenAI's market dominance and makes true competition functionally impossible.
Now let's address OpenAI's likely defense. They did change their structure to a public benefit corporation, a PBC. But Musk's team dismisses this as core argument 28. Superficial rebranding. Claim is that the transition to a PBC is just a superficial rebranding that doesn't really restore the original nonprofit safeguards.
This is about legal substance versus PR spin. While a PBC does require management to consider a specific public benefit alongside maximizing shareholder return, it is still fundamentally a for-profit entity. It lacks the severe legal accountability and tax restrictions of a 501c nonprofit.
So it's a half measure.
Musk's team will argue it was a cosmetic attempt to mitigate the damage from the earlier pivot. It provides a veneer of altruism without reversing the core financial incentive, which is still profit maximization, that overrides the mission whenever there's a conflict.
The penultimate argument, core argument 29. Winning the race over solving AI just reiterates that violation of the original safety mandate. The focus has shifted from solving AI, making it safe and aligned, to simply winning the AI race, regardless of the safety implications.
It connects the corporate structure right back to the existential risk. When you're in a race to deploy, safety and alignment research become secondary. They're slow-moving costs. Solving AI means collaborating on universal safety standards. Winning the race means deploying first to secure market share.
And the argument is that this shift represents the total failure of the original mission.
The total failure of the mission, which was focused on existential risk mitigation. The commercial structure demands speed and scale, even if it comes at the cost of global safety.
And finally, rounding out all 30 legal arguments, we reach core argument 30, the call to accountability. This is the final appeal to the jury. Hold the defendants accountable to ensure that the future of intelligence is not owned by a single, secretive corporation driven purely by profit.
This is the closing statement. It's aimed right at the jury's conscience. It asks them to recognize the profound stakes, the governance of the world's most powerful technological creation. Musk's team is arguing that this case is a chance for the judiciary to enforce ethical boundaries in a field that desperately needs them, using the breach of contract and fraud claims as the mechanism to hold the defendants accountable.
30 arguments, broken down into 3 massive interconnected pillars of structural breach, personal fraud, and market manipulation. That is an absolute wealth of strategy and insight from the source material.
To synthesize the whole case for you, the listener, the legal attack plan generated by Gemini 3 is just surgically precise. The three major thrusts aim to create a narrative of total betrayal.
The breach of principles.
Arguing the foundational charter was illegally abandoned, then the deception and fraud, proving executive intent to mislead key donors and the public. And finally, market fairness, challenging the creation of an AGI monopoly built on subsidized, charitable resources.
If we connect this back to you, the learner, this isn't just about a wealthy founder fighting over equity. This case is a crucial, defining test of corporate ethics and legal oversight in a time of unprecedented technological speed.
That's right.
Can a company legally take billions under the banner of charity, pivot to aggressive commercialization when the tech becomes valuable, and face no meaningful legal consequence? OpenAI's defense will argue necessity, adaptation, and that their current mission is still beneficial. But Musk's team is clearly focused on the broken contract and the specific intent behind that pivot.
Exactly. Why should you care about these 30 arguments?
Yeah.
Because the outcome of this trial will legally define the parameters of how AGI will be governed globally. Will the development of the most powerful technology in human history be controlled by altruistic, open-source principles and safety mandates?
Or will it be dictated by commercial pressure and the relentless desire for market dominance? The precedent set here will influence every future scientific and tech initiative that seeks public funding under the banner of being a nonprofit.
It is the ultimate question of whether the mission can survive the monetization.
And as we noted right at the top, the entire framework for this deep dive, these 30 detailed, distinct legal arguments, this strategic blueprint, was provided by a competing AI model, Gemini 3.
The irony is just inescapable, and it's a profound thought experiment. We are analyzing the arguments against one of the world's leading AI companies, and those arguments were formulated by a rival intelligence. The source material highlights this as a critical test of AI's capability to navigate complex legal strategy.
Which raises a really important provocative question for you, the listener, to mull over long after this deep dive is done. If AIs are increasingly fighting our most complex legal battles over the governance of future intelligence, and if those AIs can generate strategies rooted in concepts like deception and fraud, how do we, the human jury and society, determine the objective truth when our primary source of legal analysis, strategy, and even factual synthesis is itself an algorithm? What are the implications if accountability itself becomes an algorithmic calculation? We've analyzed the arguments, but the judge for the whole ecosystem might ultimately be invisible.